Constitutional Court began hearing two challenges to the Electoral Amendment Act today. At the heart of the challenge is whether the Act is unfair to independent candidates. In calculating the threshold to stand as an independent candidate, is the dice loaded against that person? There's also the argument that only 200 of the 400 seats in the National Assembly are available for individual candidates. This devalues the power of a vote placed for an independent. Of course, the other 200 seats are decided by proportional representation, which relates to party lists. So let's speak to one of the applicants. Mmusi Maimane of the Build One SA party joins us now. Mmusi, thank you so much for joining us. So if we wind back a bit, in 2020, the Constitutional Court decided that the then existing Electoral Act was unconstitutional because it didn't allow individuals to stand in national and provincial elections. So Parliament then went back, amended the Act, and now it's back at the Constitutional Court because you're saying it's still not fair. Individuals are allowed, but the bar is too high and votes are not as powerful for an individual as they would be for a party. Have I got the essence of the argument right?
Yeah. Good evening, Sally, and good evening to fellow South Africans. I think the very essence of the argument is correct. The broadening of the argument actually was always about seeking accountability, because actually that's what South Africans want. They want to know who they vote for directly. That's why in the moving of the bill, in the ruling that Judge Madlanga made in 2020, he made the words Amandla Ngawe to become a reality, to say that let the parliament write into law something that empowers citizens to know. Now, what effectively happened, which is the second point that you make, is that actually the power still has been retained in the political system. It's been poorly used. I think it's malicious compliance. And I think for citizens out there today, where they were to give expression to say, we think this person must represent us in parliament or in a provincial legislature, not only will they need to get 90,000 votes for that person, which is almost double the amount that a party would need to get. That shows that the rules are already immediately unfair. But the second thing is that the demand that they must be able to show their IDs, their signatures, so that they can show over 14,000 people must show first up that we support this person, is already an indicator of the fact that they are trying to intimidate people into not supporting an independent candidate or someone who the community may deem fit to represent them. It's why when we put up Build One South Africa, we wanted to be intentional about we want for citizens to know who they vote for. That's why I went out and said, let the best candidates stand up so that people can know them up front, because the principle of accountability must never be lost within a democracy.
Talk to me about, and I was listening to Badlinder, who's acting for the government. He says that the only real issue that has to be decided by the court, if I'm understanding him correctly, is this issue that currently only 200 seats of the 400 would be available for individuals to grab if they got the right amount of votes. And the suggestion, rather, is that 350 seats are available, and then only 50, I would imagine, going to proportional representation. Is that the nub of this current sort of argument?
That is one of the arguments that are on the table, and I think it's a very important argument, because if the threshold, if the mathematics that you use is 350 for the seats available for everybody to contest in, it means the threshold immediately lessens, which actually makes the rules of play for everybody fair. But if you keep it at 200, you achieve the very problem I was describing to you earlier, that an independent candidate would need 90,000 votes and a political party simply 50,000 votes or less than that to achieve. The other great difficulty is that should an independent candidate die or resign in the course of that, those votes then get immediately transferred back into political parties, which is a misdirection of the will of the people. So for me, what we really needed to do is effectively, Parliament should have done its job properly and amended the Electoral Act to make sure actually accountability was done. That when the President signed this bill into law, he would have anticipated such issues. And as part of the recommendation, a panel should have been established to deal with the broader issues of electoral reform. That was within 4 months. And ultimately, that in the calculation of seats, this should have been a consideration, because the risk is not delaying an election. The risk is running an election in a law that is actually disadvantageous to anyone who's wanting to stand, and even for a new party. For example, new parties registering into the elections now, for their purpose of participation, would need over 10,000 signatures to begin the election, which, as I said earlier, would mean citizens who now who support that party have to publicly declare so, which in many ways is about revealing their vote up front, which undermines the constitutional principle in this regard of your vote being a secret.
And in the meantime, the IEC is in a state of near panic because they're saying this issue needs to be resolved quickly because this constitutional court decision will have a bearing on the coming elections next year, won't it?
Of course it will be. But I think the IEC here needs to be free, it needs to be fair in its commentary, because when the matter was brought before Parliament, the IEC said it can only be referee and made no submissions, because I presented to the IEC in person to say to them, this is what their calculations will look like. I even brought Mr. Atkins on which the calculations come on board. And therefore, I feel it would be unfair to say to them now, well, they are panicked, because the panic was created by Parliament itself.
I hear you.
And I would say...
I hear you, but let's get practical. Yeah, let's get... What is going to happen?
What needs to happen, that we are asking for the judges to actually make a supervisory order, which they've done in the SASA case, to ensure that the law is constitutional, bring it down to 350, which is an option that's available that would meet constitutional muster, and ultimately scrap down this new provision, because it's a new one for participation at 10 to 14,000, which is...
That sounds... Sorry to jump in, just from a time point of view. Already today there was a suggestion that sort of almost like an amendment to the Electoral Act, but that the Constitutional Court says, right, this is what we're going to do. 350 is available to everyone, including the independents, and 50, off you go. But already, and even the judges in the Constitutional Court today were going, hang on a minute, this is starting to sound like a blurring of those separation of powers, because the reality is that's for Parliament to sort out. Our job only is to look at this Act and to say, is it actually achieving what we asked it to achieve? How concerned are you that they won't be able to do that because they're too concerned that there'll be a blurring of the separation of powers between the courts and the government?
No, I think the historical matter of the SASA case proves that actually the Constitutional Court can issue supervisory orders with clear timelines that show how it needs to be done. And therefore, when Parliament fails, Parliament has failed the people of this country and produced a bill that's poor. Let's not run an election illegally because we're under time pressure. Let's make sure we do all the right things. Let's give the supervisory order, and let's ensure the elections are free and fair. Because if you don't do that, a la Zimbabwe, you will end up in a state where election results are challenged, which will add a further delay, which none of us actually want.
All right, well, that matter continues tomorrow. Completely fascinating, and as you've explained, does have a very clear bearing on what happens when we go to the polls next year. Mmusi and Maimane of Build One SA. It's one of two groups challenging the constitutionality of the Electoral Amendment Act in the Apex Court. They argue it is still not fair for independent candidates. That matter continues tomorrow.